All right, everybody. Well, we're going to get started here with our second to last session of the day, discussing Secure Act 2.0 with Peter Wall. One thing I want to bring to your attention before we jump into that, I had passed along after Stephanie Parker's session that we had her notes in the resources area of the platform. Apparently that was a little premature. They are there now, so if you're looking to get those resources, you can go over to the tab that says resources on the platform, and that'll give you an option to download them and have those for your purposes. All right, so we're going to pass it over to Peter. Peter is the Director of Fiduciary Services at TrueLink Financial Advisors with more than 20 years of trust administration experience at national bank trust companies. He's well known for his deep expertise in special needs planning, elder law, and fiduciary responsibilities. Before joining TrueLink, he developed and led an elder law and special needs trust division at a national trust bank. Peter serves as on the board of directors for Easter Seals and several estate planning organizations. He's also a frequent speaker at national and regional conferences on topics including estate planning, taxation, and trust administration. And so at this point, I'll pass it over to you, Peter.
Amazing. Thanks, Luke. Thank you guys so much for having me back. It's exciting. Really happy to be here. Housekeeping items first. Any questions that you have, throw them in the chat. That'd be amazing. That way I can see them and we'll get to them when it's appropriate. As I was sitting here waiting to get on, I was looking here at this candle chart right here, showing the market going up. Remember those days? Weren't those days nice? I kid a little bit. We had a nice little rally today. But what we're really here to talk about today is the Secure Act 2.0, and some of the issues, quite frankly, that have popped up since its passing. So I know everyone is super excited at almost 2 o'clock on a Tuesday afternoon to talk about taxes and IRAs and things like that. But we'll try to make it fun. And I'm going to show you a couple of instances, a couple of things, a couple of issues to look out for as you're helping your clients navigate this new rule as it relates to retirement vehicles, and also some administrative challenges that we've seen, a lot of our fiduciaries run into. But before we really sort of get into the nuts and bolts and what I think, but again, I'm a huge nerd, what I think is the fun part of IRA administration for trusts and for fiduciary vehicles, let's just take a step back. Are we not seeing the PowerPoint?
Yep, I think it popped off there. So
okay, let's try it again. Thank you, Luke. How about now?
We're seeing it.
All right. So let's take a step back and kind of go over just the basic ground rules for IRAs, for the Secure Act, for things of that nature. Even for those, those of us who are well versed in this area, I always find that when we go over some of the more complex topics, just the more times I hear it, the more maybe I learn by repetition, the sort of better that it sinks in. So when we're talking about the Secure Act, we're basically talking about IRAs, whether those be inherited or they be your conservatees, your wards, things like that. Just a couple of notes here. I think, for those of you who've seen me present in the past, I'm not the kind of guy that goes over every single bullet point on the slides. Y'all can read. And so these materials kind of go over and give you a good overview sort of what's going on. One thing I'll note here, whenever we're contemplating an early withdrawal from an IRA, and that would be a withdrawal from an IRA before the age of 59 and a half, just note that 10% federal tax penalty is applied unless you have one of those exceptions that are listed there. And of course, any income withdrawn from an IRA, except for Roths, is taxed as regular income. So basically, right, put the money away pre-tax, and then when you take it out, then it becomes taxable. That's oftentimes you'll hear a IRA referred to as a tax deferred vehicle, and that's the reason why. Okay, so contributions generally tax deductible. We already talked about that. I also, for those of you who know me, will come as no surprise, I get ahead of myself in the slides. as well. You can see here we are now in an expanded catch-up contribution mode for ages 60 to 63. So you can see there's an extra $10,000 that older working adults can put into their IRAs. A lot of times when we're talking about IRAs, it gets very confusing when we talk about, hey, is this a traditional IRA? Is this a Roth IRA? Is this a rollover IRA? Basically, what you need to know is that a rollover IRA means that it's rolled over from another plan, basically. So this is generally, you leave your job, you had a 401k plan there, you can keep it there, or you can roll it over to an IRA, maybe transfer it to your preferred investment advisor and things like that. When you roll them over, when you roll IRAs over for your clients or for yourself, this is sometimes called a direct rollover or a custodian to custodian transfer. And basically what that means is either, you liquidate all of the assets, the stocks, the bonds within the IRA, not taxable. Capital gains are generally not taxable in IRA vehicles. And then you do a wire transfer, ACH, from one custodian, think like Pershing or Schwab, to a Fidelity or another custodian. This I can't recommend this enough. When you're contemplating doing this, do that. Do a custodian to custodian transfer so that first of all, you've got an amazing paper trail, right? You can show all dollars from this went over to this, inherited IRA, whatever the case may be at the successor custodian or successor advisor. It also means that you don't have to withhold any taxes because you're just doing a rollover from one institution to another. Now, there is this thing called an indirect rollover where, you can have the check come directly to you, and then you have 60 days to establish a new IRA with the exact amount of proceeds that came out of the transferring IRA. Now, where does this become a problem? If you're doing some sort of withholding, the IRS still expects you to put the full amount in the new IRA. So imagine, let's make the math easy. Imagine we're doing $100,000 from one IRA, or excuse me, from a 401k to an IRA, and you decide to do some withholding. You say you do 10%. Again, let's make the math easy on old Pete here. So you withhold $10,000. Does that mean you can so the transferring institution will hold that $10,000, send it to the IRS, but then does that mean you only have to fund the new account with $90,000? It does not. You still have to fund it with that full $100,000. And you can be waiting for quite some time for the IRS to, refund any overpayment or withholding. So as a general rule, now certainly always exceptions apply. Withholding from an IRA, I mean, unless you have a full picture of your beneficiaries, tax implications is generally just more of a hassle than it's worth. Okay. So let's move on to the Secure Act. So this stood for the Setting Every Community Up for Retirement Enhancement, and it was passed, actually, quite frankly, it was passed to everyone's surprise right at the very end of 2019. No one really saw this coming. It had been discussed. And of course, there were issues in it. And this isn't unusual, right? A lot of times when tax law or, retirement benefits law, things like that, get passed, there's oversights and there's errors. And so that's why it was followed up by the Secure Act 2.0, which was passed at the very end of 2022. You can see here, Secure Act 2.0 was actually made up of a couple of different acts, including the Rise and Shine Act and the Earn Act. And what did we learn from this? Well, apparently we learned that the government really likes to make up acronyms. So a little silly there, but that's what it was. So this whole act, guys, really flipped planning, especially for people with disabilities, on its head. So in the past, we used to always say due to tax consequences, public benefits / resources, consequences, as planners, hey, you mom and dad, if you have a disabled child or a child with a disability and a child without a disability, it's generally better to leave all of the retirement assets to the person or beneficiary without the disability as opposed to the beneficiary with a disability. Well, this got completely flipped on its head by the Secure Act. And there's this real opportunity for attorneys in the audience, planning attorneys, to reach back out to your clients and say, hey, we need to take a look at your retirement plan and your estate plan because the recent changes to the law we could have a more beneficial outcome if we just sort of rethink this. But basically, what the Secure Act did, guys, was it eliminated the required minimum distribution or RMD stretch for, quite frankly, most beneficiaries. So it used to be that if I wanted to leave my IRA to my child upon my passing, that then they could take that inherited IRA and they only had to take out the required minimum distribution. Makes sense now, right? The RMD, which was calculated using IRS tables based on their life expectancy. Well, that doesn't happen anymore. Now, generally, we're in a 10-year period. We're going to go over all of these rules here in a second, unless you qualify as what's called an eligible designated beneficiary, which again, we're going to talk about here in a second. So really, this was really was a monumental act, not only for people planning for retirement, people planning for their estate plan, but especially for planning for people with disabilities. And maybe I'll just take a second here right now to note how friendly the IRS generally is to people with disabilities. If you think back at some of the things that the IRS has done, including this Secure Act, which, spoiler alert, people with disabilities are able to take out an inherited IRA over their lifetime using their life expectancy. You also think back to the ABLE Act or those tax advantage savings accounts for people with disabilities. That's an IRS regulation too, as is the fact that the IRS will treat a first party special needs trust as a grantor trust for income tax purposes. Generally, a lot of times, I should say, people with disabilities might not necessarily have a lot of outside income. They may not have jobs and just receive SSI. Therefore, making all of the earnings and income, in their first party special needs trust, therefore taxed at their rate. And if they're not earning other income, a lot of times they're not even required to file a tax return. So again, yay to the IRS. Thank you so much for being amazing to people with disabilities. You can see here there are also some new RMD requirement dates when you have to start taking out the funds. And all of this of note applies only to IRAs inherited after January 1st of 2020. So you've got other inherited IRAs for the benefit of trusts or for benefit of people with disabilities or people under conservatorship, people under guardianship. Those rules still apply if it was prior to 2020. Okay. The Secure Act 2.0 also contained approximately, I think it was just shy of 90 separate new provisions. It's a lot. I don't expect you to read them all. I did that for you and sort of summarized what I think are some of the key terms here. You can see here the qualified tuition Q-tip, right? Not a qualified terminal interest property trust, but a qualified tuition plan. You can be rolled over to a Roth IRA now under certain circumstances that can be very, very beneficial. There is supposed to be a 401k lost and found database. Think of this like your state's achievement office, easy for me to say, where you can look up and find, lost property for decedents, for example. Now, I haven't seen any movement on that. Haven't been paying attention that closely either. I do have a Google search, macro for it. But if anyone knows about that, please let us all know. Pop it in the chat. But that can be very, very useful for personal representatives, executors of an estate, and things of that nature. And then one thing I will note here that has been very, very useful is this missed RMD penalty reduction. So it used to be that if you miss the RMD, which is very easy to do, imagine that you take over the trust after the original grantor has passed away. And let's say they pass away in December and hadn't taken their RMD yet. Are you going to get your, letters testamentary and things of that nature appointing you as PR from the court within that 30-day window, so you make sure you take that RMD? Probably not. So if you missed it in years past, the penalty was 50% of the RMD. And now it's reduced from 50% to 25%. However, if you get it done in the second year following the due date, it's only 10%. Now, a lot of times there are exceptions to this. A lot of times you can write the IRS, I think it's a form 5129. I could be wrong on that. that you can fill out and say, hey, problems with the custodian, delays from the court, et cetera, et cetera. We are fully considering the IRS's position. That's important. That's IRC language. Just asking for a reprieve of this penalty. I've written several of those or filed several of those forms in the past and have always been successful. The IRS isn't looking for gotcha moments. They just want to make sure that you're not deliberately delaying an RMD from one potential tax year to another. Let's imagine you had a very high tax year one year and we're just like, oops, I forgot to take this RMD. But if there's a good reason, I've been very successful in filling out those forms in the past. Okay, so now let's get down to the nitty gritty. We're going to talk about the different IRA beneficiary types. There's basically three types that we need to really focus on as we're doing, conservatorship, as we're doing trust administration, inherited IRAs, or even informing our clients who are doing estate planning. So the very first one is the one we're all trying to avoid, right? It's called an NBD, or a non-designated beneficiary. This is when you name an estate, a charity, or a non-qualified trust, and there's the definition under there, as the beneficiary of the IRA. So we used to always say, hey, charities, in particular, have a heart, but not a heartbeat. And that's really what the IRS is saying. Hey, this isn't a real entity. They're probably not going to pay income tax on it anyway. But on any of these, or if you have a non-qualified trust, you got to be careful, drafters, right? That the qualified trust thereafter does actually name all the beneficiaries in the trust document. It can't be non-specific. Then we're subject to taking out that IRA over the next 5 years, which is kind of what we want to avoid, right? We want to keep the money in the IRA for as long as possible, or as long as prudent. Let me say it that way, so that we can gain that tax deferred growth advantage. It can really be a great advantage. The whole point, I think, of my entire presentation is, hey, how can we maximize that particular tax benefit, that tax deferred growth? Leave it in the IRA, let it grow longer, so that therefore, when it comes over to the trust, when it comes to that beneficiary, eventually through required minimum distributions or otherwise, we've elongated or lengthened the amount of time that the trust will last, for our beneficiaries, and really, cover their needs. You can see here, though, if it's usually 5 years, but if the account owner was already the original, when I say account owner, I mean the person who owned the IRA before they passed, then if they were over 72, then you use the decedent's life expectancy. So you go to that table, that IRS table, you look it up. It's going to be right around 5 years, right? So actually a little bit longer. This is my favorite IRS or IRC, Internal Revenue Code term of all time. This is the ghost expectancy rule. So you either use the 5 years or the decedent's life expectancy if over the ages of 72. That ghost expectancy rule, just my mind always goes straight to Scooby-Doo. Product of my generation, I guess. So let's walk through some of the issues that we've seen with NDPs. So let's say the family member meets with a pooled special needs trust or a special needs trust trustee. I mean, insert any fiduciary here. They establish, a special needs trust for that beneficiary, but they didn't name the special needs trust as the beneficiary and selected their estate. Now, this isn't as uncommon as you'd think, because there's a box on a lot of custodians' account opening forms that say, hey, where do you want it's usually on their beneficiary designation form. Where do you want this money to go? Do you want it to go to a trust? Do you want it to go to blah, blah, blah? You want it to go? And so is it inconceivable to think that one of our grantors could see that estate box and be like, hey, I have an estate plan. I'll send it to my estate. And they check that box. And all of a sudden, we've got a real problem here. Of note, anything that and this might be another example, but what the heck, right? Of note, anything that the IRA beneficiary designation form says supersedes any estate plan. So you can have the best estate plan humanly possible out there, but if the grantor, the owner of the IRA, doesn't name the special needs trust, the trust for the child themselves, whatever you've decided on that beneficiary designation form, guess what? that will, that trust is completely, it just doesn't matter. It's ineffectual. And the IRA custodian will do what the grantor said on there. This is also true for like checking accounts, investment accounts, and things like that. So real opportunity here, planners, to again reach out to your clients and say, hey, I know we talked about this. Would you mind just sending me the beneficiary designation form just so I can double check and make sure that all this work that you paid me for doesn't go for naught? If this happens, you do have some potential solutions. You can petition a court. Guess what? If the IRS, disagrees with XYZ district court in, whatever, state that you happen to be practicing in, they're not really bound. That court doesn't have jurisdiction over the IRS, right? So that comes with some risk too. You could also ask the IRS for what's called a private letter ruling or a PLR. We'll talk about those in a second. Those can be very specific. Excuse me. Those can be very costly and they're very specific. They only truly apply to the particular set of facts at hand. Okay, let's talk about designated beneficiaries. This is going to be probably the majority of the beneficiaries that we're going to be dealing with, right? If this is an individual or a see-through trust, and there isn't these exceptions that are created for what we call eligible designated beneficiaries, which by the way, I guess what we're going to talk about next. Then we have 10 years. Okay, we've got 10 years to deplete that particular IRA, and sort of however you kind of want to do it. You can see here there are some requirements there. But what if you've got a family member, they establish a testamentary trust? This is the exact same fact pattern, right? I've highlighted what's a little bit different here, folks. So, but instead of naming the special needs trust, they named that special needs beneficiary personally. Automatically, we're stuck in 10-year land, okay? Generally, right? So again, and because you've named that person personally, it's also a resource for public benefits determination. Recall that in special needs trusts, a special needs trust can only be valid if the beneficiary has, or excuse me, public benefits can only, sort of happen. And generally, I'm talking about SSI or supplemental security income. If that beneficiary has less than $2,000 in resources or assets to their name. Well, if they have an inherited IRA that all of a sudden is in their name completely and it's well above that $2,000 amount, guess what? Ugh, sorry, but in most states, that Medicaid or that SSI agency is going to be like, well, you have to spend down the entirety of that IRA before you can get back on SSI. All right, well, maybe that's not such a big deal, right? Because SSI isn't all that much money, and maybe we can just supplant that, right, with proceeds from this IRA until we do spend it down. But if your beneficiary isn't receiving any SSI, what else aren't they receiving? They're not receiving Medicaid, right? And that can be devastating. The cost of private pay medical care, or even, AMA/Obamacare, Medicaid, may not cover everything. So this can be a real problem. You do have some potential remedies. You can petition the court. We're going to take a look at this PLR here in a second, or you can assign it to a first party special needs trust. Now, I've had some success with assigning an IRA that's left to a beneficiary personally to a first party special needs trust by doing a court petition. But again, that court's rulings may not necessarily apply to the IRS. It may not apply to SSI. If you're going to attempt to do this, my friends that are elder law attorneys, be sure that you copy all relevant parties on the petition to include Medicaid, to include Social Security, so that they have the potential to object. Better to find out now than to find out 10 years from now, right? And I understand the SSI's position on this. However, I wish we could get just a little bit more clarity. I would imagine yeah, I'm in Colorado, and I'm going to go out on a limb here and say that our Medicaid agency, which is in most states is really it's really the Social Security agency that sort of controls SSI. For us in Colorado, it's more Colorado Medicaid, one of the most draconian in the country, and will literally make you drain even if they allow an assignment to a first party special needs trust, they will make you cash out that entire so normally they won't let you assign it, making you therefore cash out that entire IRA, which is all taxable, remember, to our beneficiary. So all of a sudden, the beneficiary who's never paid taxes before is hit with like $300,000 in income, as an example, coming out of this IRA, and then put it in a first party special needs trust. That doesn't make sense to me. Why wouldn't you allow it to stay in the IRA and grow tax deferred for their eventual remainder person claim? I don't get it. You think that they would want to take advantage because recall in a first party special needs trust, when that beneficiary passes away, any money left in the trust can be used to satisfy what Medicaid has paid for them, either over their lifetime or upon establishment of the trust. So why wouldn't you, as the Medicaid agency, want to take advantage of a tax deferred benefit plus depleting right off the bat the trust by the 10%, well, not the 10% penalty, but all of the income um, tax due on that first party transfer. Don't get it. The thing that I do understand is that first party, um, the first party designation um, to the IRA is technically revocable, but if we could figure out a way to make it irrevocable, I think that that would solve a lot of issues. Haven't had a lot of success making that argument. And what I mean by that is generally, as a general principle of law, ERISA accounts, 401ks, IRAs, things like that are not generally assignable. And that's basically what we're trying to do. We're trying to assign, in this particular situation, the IRA to the first party special needs trust. Therefore, could the beneficiary come back 5 years later, because remember, it's in their name, come back 5 years later and say, you know what, I don't want to send that to the special needs trust. I'm going to cash it all out, et cetera, et cetera. I guess technically that's correct. But if we could just find some middle ground, I think everybody would be a lot happier. Okay, that was a tangent. Wow. let's uh, let's talk about private letter rulings, or PLRs. So the most important thing to recall about PLRs, they're not law. They're not even really truly guidance. They are a private letter ruling from the IRS that is 100% specific to the case at hand. Has to have the case, if your case has the exact same fact circumstances as that PLR, then I think you can be assured that this particular PLR would apply to your particular case. And basically, you're asking the IRS, hey, listen, this, that, and the other thing happened. This was the intent. What do you think? This is what we want to do. And the chief counsel for the IRS will be like, in this particular case, this is good, this is bad, whatever. So we can rely on kind of what the chief counsel for the IRS was thinking when they wrote that PLR. But be careful of anyone who tells you this PLR totally applies to your case or every inherited IRA case for an S&T moving forward. It doesn't. It just doesn't. But we can sort of divine or sort of squeeze out a little bit of guidance when it comes to these PLRs. So let's take a look at this particular PLR. So we have a family. Father names 4 sons individually as IRA beneficiaries, but one son is a person with a disability, and he was a minor receiving SSI and Medicaid. Oops, right? Should have named the special needs trust for that. During the pendency of all of this, the IRA for the 3 sons without a disability are taken care of and set aside for their benefit. The IRA share for the son with a disability was set aside, and no distributions were taken. The mom in this case was brilliant. She was the guardian, et cetera, et cetera. She did everything right by the books. You can see here. So she's like, okay, let's figure this out. And this is all the way back in 2006, right? So you can see that's how the PLRs start with the year. So she establishes a first party special needs trust. Bummer, right? Because obviously dad's intent was it to be third party money to fund the beneficiary. In other words, should the beneficiary predecease, the funds in that IRA, then those funds could potentially go to the remaining funds left in the IRA or in the trust could go to those other three sons or to the mother or what have you. Unfortunately, because of this error in beneficiary designation, we don't have that opportunity. But hey, mom steps up, creates a first party special needs trust, and then she seeks a PLR to transfer the IRA to the S&T as a non-taxable transfer and use the son's life expectancy for the required minimum distributions. You can go through the different arguments here. Mom had a great, either drafting attorney or CPA, probably both, helping on this PLR. And during while they're waiting for all this to happen, and of course, nothing with the government moves quickly. It's going to be even less quickly now that the Treasury Department has somewhat been gutted with people being let go. So the you can see here that mother disclaimed any of her interest as a first party potential beneficiary of the first party trust. Okay, so normally, let's imagine, and I don't recall in this case that this particular beneficiary, this son with a disability, may lack capacity, therefore couldn't effectuate where any remainder funds in the special needs trust after Medicaid had been paid back, right? Where it would go. If mom had been a beneficiary in that class, she would have been known what's called a adverse party in Internal Revenue Code language, because she stand to potentially benefit from this. And so if he didn't have capacity, it would go by laws of intestacy, and mother was probably in that line somewhere. So she immediately disclaims any potential interest to this, and takes required minimum distributions into the guardianship. So because she did all of this right, and all of this was blessed by the IRS, you can see here that the transfer was allowed of the IRA to be for the benefit of the first party special needs trust. So marshal your IRA assets as promptly as possible, because there are certain timelines as to when you need to make the election as to what kind of required minimum distributions you're going to take. And obviously, when it gets this sticky, get a tax professional involved immediately. Okay. Now this one's really tricky, guys, and unfortunately, I've seen this 4 or 5 times already. So same fact pattern, but the IRA owner, instead of naming the special needs trust sub account, names their revocable trust as the beneficiary. That revocable trust then names the special needs trust sub account as a remainder person after estate administration is concluded. This is actually really common. Okay. Go through. There were a lot of practitioners that when um, someone would pass away, they've got, a bunch of kids. What happens is they're like, okay, we want to take advantage of the pour over provisions. So we want all of this estate to pour over into, the trust, my trust. Let's imagine it's me, and the ultimate remainder persons are, special needs trust for my kiddos. Um, we want all the assets to pour over into Peter's trust. Peter's trust now becomes irrevocable, and a lot of times you'll see this referred to in the trust document as an administrative trust. So you have this trust that was revocable while I'm living. I've got a revocable living trust. I pass away. My will says, hey, PR, pour over all my stuff into my trust, and then the trustee of my trust will then distribute it out. So during the pendency of the estate planning, or excuse me, the estate's administration, pour all this stuff in here, and then then we're going to separate everything out to two special needs trusts for my kiddos. Right? Makes a lot of sense. It doesn't anymore, because now what we've done is we have a revocable trust. Fine, that's me, right? As a tax entity, that's me. Then we have an irrevocable trust after my death, right? So all of a sudden, we've got a new trust here. And then the special needs trust. Guess what? The IRS is only going to look at that first irrevocable trust. So are the custodians, right? Sometimes they have, because this has been a problem, there are custodians that have exception forms that have to be reviewed by their legal team and things like that. But now all of a sudden, my IRA is not going to be payable to the ultimate remainder person that I wanted, which are the special needs trust. It's only going to be payable. The custodian, the IRS is only going to recognize it as payable to that administrative trust. We've got 10 years. And really, I wanted it to go to my young kiddos so they could stretch it out in their special needs trust over their lifetime. So, real problem, and it's actually more common than you think. So, we've come up with a couple of solutions here. Petition the court. I'm not going to go over that. What if you just kept that pass through or that administrative trust open for 10 years to receive the required minimum distributions? This requires a tax analysis, because what you don't want to do is just fine, throw up your hands, cash out the IRA. It's all taxed as income at the top trust compressed tax rates of up to 37% in that administrative trust, and then pass those proceeds on to the kiddo special needs trust. So what if we just keep the administrative trust open? That's sort of an elegant solution. So we can keep that administrative trust open for 10 years. Bummer that we missed the life expectancy, but I mean, so be it. Again, go back and review your beneficiary designations. And then, every time that money flows into the administrative trust from the IRA, it's taxable at top trust rates. However, you're turning right around and you're shooting that money out in that same tax year to those special needs trusts, meaning we've got what we call distributable net income. So we've got income coming in, then we've got income going out. Then that income is not taxable at the administrative trust level. It's taxable at the special needs trust level, which, if my kiddos are using it, hopefully that income will get pushed out to them, again, through DNI, or distributable net income, and taxed at their personal income tax rates. This costs a lot of money. You got to keep an extra trust open. You've got, potentially two different trustees, maybe three trustees, depending on, who's the trustee for the kiddos trust. You've got multiple tax returns to file every year. And so that's really where that cost benefit analysis comes in, right? How much can we push out ultimately to the beneficiaries would be the great idea 2 steps later. And what makes the most sense in terms of administrative cost and things like that. But this happens a lot, so keep your eyes open for this stuff. Okay, now finally, the eligible designated beneficiary. Elizabeth asks, can you transfer an IRA to an ABLE account? You sure can, but you're limited to $17,000 a year. So you do $17,000 and it's still taxed as income. So the ABLE account just recall, ABLE accounts are fantastic for shielding resources, but income is income is income. It won't change the distribution from the IRA of that $17,000 for the one beneficiary that year. It won't change the nature of that being taxable income. Eligible designated beneficiaries. These are the folks that get to stretch. Yay, we get to finally stretch over their lifetime. So spouse makes sense. Beneficiary with a disability, beneficiary who is chronically ill, individuals not more than 10 years younger than the decedent, or minor children of the decedent. Of note, that's only while they're a minor. So it doesn't, excuse me, I almost said something wrong. It doesn't matter what the age of majority is in your state. The IRS was like, I'm not dealing with that. I don't care that at Texas, it could be 14 for an emancipated minor. In Colorado, it's 19. In New York, it's 18, like whatever. They didn't want to deal with that anymore. And so they made that age 21. So the minor with a minor child of a decedent could use their lifetime RMD stretch until they turn 21. And then the 10 years kicks in as a designated beneficiary, DB. Couple of things though, also included as an EDB is a special needs trust, and you can see the IRC there too. So in addition to these folks here that we talk about, beneficiaries, disability, chronically ill, et cetera, they also go on to say, okay, we will also count a special needs trust as a person with a disability for this purpose. However, it has to be a see-through or qualified trust. What does that mean? You can see the you can see the qualifications there. The trust has to be valid under state law. It has to be irrev. It has to be, provided to the custodian. All countable beneficiaries must be identifiable, right? That's that. So we don't fall into NDB land. And all countable beneficiaries must be individuals, and thanks to some tireless efforts, and this only applies right through for see-through and qualified trust, through some tireless efforts from NALA, the National Academy of Elder Law Attorneys, and the Special Needs Alliance, SNA, and ARCs, et cetera, et cetera. Now, remainder charities are now counted as individuals. Okay, so it used to be, bam, you name a remainder charity, which, a lot of people with disabilities get a lot of help from, and I will here in a second, Elizabeth. Excuse me. They used to say, hey, if you give anything to a charity, that's you're back in DB land, or NDB land. But now what they say is, hey, people with disabilities often get a lot of help from nonprofit organizations, and so grantor, if eventually you want to, leave the arc, for example, money after your child's death, after they've, if they predeceased the funds in the IRA, that's fine too. So great win there. Uh, Thanks for your question. Again, Elizabeth, revocable trust means that you can change it. So revocable, generally trusts are only revocable by the grantor or the settlor. So if I'm writing my own living trust, I can change it at any time. We know this. We can change beneficiaries. I can change any provisions, et cetera, et cetera. Irrevocable means can't be changed. Can't be changed by anyone. Obviously, the courts can always interpret and change irrevocable trust without changing that nature, but irrevocable means nobody can change it. Okay. The great thing about this EDB is that it means continued qualification for means tested public benefits by our beneficiaries. In other words, they don't have to spend down that IRA as long as it's appropriately designated to the special needs trust. Again, allows us to grow that trust, or excuse me, the trust assets really via the IRA for a longer period of time. And it doesn't push our beneficiaries into a higher tax bracket simply because they're receiving income through the required minimum distributions or any distribution that they take from a IRA. Okay, so this you can kind of look over there is our S&T, a see-through trust or a qualified trust. Here's all the different rules in general. Gosh, I would hope that this is true for all special needs trust. You're not going to have a conduit trust. If you have a conduit trust, you have a problem. A conduit trust says, hey, trustee, as soon as you receive any money from any qualified plan, retirement plan, 401k, IRA, you have to immediately turn around and give that money to the beneficiary, generally in cash, right? That would disqualify our beneficiaries from our special needs trust beneficiaries from public benefits because they have a right. They don't have a right. They will receive that money as soon as you take the RMD, which will potentially kick them off. They'll have income. They'll have a resource, potentially kick them off of SSI. That's what a conduit trust says. And a lot of planners would use this for sophisticated tax planning, right? Hey, most of my assets are in this IRA. I don't want them to be ever taxed at the trust level, which you can see the 2025 compressed trust tax rates there in the corner chart there. We want to avoid that. One great way to avoid that is just to shoot all the income directly to the beneficiary. Great for tax planning, not so great for public benefits or special needs trust planning. Accumulation trust is what most of us are going to be dealing with a special needs trust. I hope all of us with a special needs trust. And this means that any distribution of income, principal, what have you, is at the sole discretion of the trustee. So they can accumulate, right, that income that's coming out of the IRA and keep it and maybe spend it on the beneficiary and maybe not. It's tax advantaged to spend that income because, again, we're talking about DNI and stuff like that, which we're not going to talk about today. We're not going to get into the intricacies of distributable net income, but it's at the trustee's discretion to accumulate that income, and it only goes out to or for the benefit of that beneficiary in the trustee's discretion. Okay. Now let's talk about a lot of the questions that we get about see-through or qualified trust. And this comes down to tiers. And so we have to look at each tier to make sure our trust, and this is important for us as fiduciaries, right? We have to make sure that our trust is see-through slash qualified. They basically mean the same thing. But to do that, we have to look at the tiers of beneficiaries in the IRA beneficiary designation form. So the first tier of this is any beneficiary who could receive amounts in the trust representing the owner's interest, blah, 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 blah. This basically means they're beneficiary, right? Do they have access to the trust? Um, and so we want to make sure that's there in place, and you can see that special note there. Second tier, could they receive any amounts in trust that were not distributed to beneficiaries described in the first tier? So special needs trust beneficiaries in general or sole benefit beneficiaries. So we're looking, when we're talking about, second tier, we're looking at the special needs trust beneficiary themselves and any remainder person. And again, we're making sure that these are people. These are, not NDBs. These are either DBs or EDBs. And then finally, on the third tier, anyone who could receive amounts after the original remainder persons die. So remainder persons of the remainder persons. So we're taking a look at all that. So basically, first tier beneficiaries count. We got to make sure that anyone who could receive any benefits is a EDB or DB. Third tier beneficiaries don't really ever count. And so really what we're looking at is first and second tier beneficiaries in an accumulation trust. If those qualify as DBs and EDBs, we're good to go. Okay. That I just threw a lot at you. Here's a great table though that's in the materials. It says, hey, what distribution schedule am I looking at? We're talking about the 5-year rule, the 10-year rule, the ghost expectancy rule, things like that. This sort of shows you how to walk through that and proceed. Okay, let's talk a little bit about required minimum distributions. How do we figure it out? Required minimum distributions are the amounts that they have to take either at a certain age or as an inherited IRA beneficiary, and which sort of table do we use? Basically, if you're dealing with an inherited IRA, you get to use the single life expectancy table one. So you go to publication. Oh boy, 590. It's on there. Good. I wanted to say 529, but that's not true. 590. It's online. You scroll all the way down to all those tables and you take a look at the single life expectancy table. However, if you're dealing with you're acting as guardian or conservator of a person, and you have to take that required minimum distribution, you just need to know how old their spouse is and whether they're 10 years more, if they're 10 years younger or 10 years older than that beneficiary, and then you either use the joint and last survivor table or the uniform life table. But this is pretty simple on how to do it. What we do, we take a beneficiary, inherits an IRA, this beneficiary is an EDB, life expectancy. Okay, so we go to the chart. We see age 38, 47. The age is 38. The life expectancy is 47. That be 47.7. That becomes our denominator. We take the 1231 value of the prior year and divide it. That's it. That's all it takes to calculate a required minimum distribution. Pretty simple. I will warn you, if you go out and use a RMD calculator tool that's online, they are not built for Secure Act rules. So, and I've played around with a lot of them. You can kind of get to it if you know what you're doing on some of them, but a lot of them, they're really dealing just with these first two, the uniform life table and the joint life table. And I get it. They don't want to try to make the determination for you. Hey, is your beneficiary really disabled? Hey, is your beneficiary really chronically ill? They don't want that liability. So just be careful when you're using some of the tools that are out there, because quite frankly, they just weren't built for this level of sophistication. Okay, we're not good. We already talked about this. Let's review the basics, shall we? So we have three fact patterns here, and they're all the same except for what I've highlighted here. Beneficiary with a disability. They've opened a third party special needs trust. You've got different ages, excuse me, of the beneficiary. And then you've got, a pooled special needs trust. I put that in there on purpose because it's a nonprofit. It's a charitable organization. How do we go about figuring out the required minimum distributions for these people who are all different ages and things of that nature? Well, it's actually really not that hard because the beneficiary is 50 in all of these cases. The IRA account owner is different, are different ages, and the remainder person is different here. So part of the Secure Act was to make this just a little bit easier. And guess what? They actually did in this particular case. It used to be that we would have to go back and calculate how old is the second tier beneficiary, how old was the decedent, et cetera, et cetera. And now you don't need to do that. Now you just look as long as everything else is equal, and as long as they qualify as an EDB, bam, we just go to that table, and we just have to know the age of the beneficiary to make that happen. Okay. Now this is a question I get a lot from my planning clients, which is, hey, I have two kiddos. One has a disability and one doesn't, and I want to treat them 100% equally. So, Pete, let's just go in there and let's divide all the assets in half and call it a day. Not so fast. Let's think this through, right? You can see here, again, y'all can read the different sort of things that we've got going on here. We've got a daughter with a disability. So we should be setting up a third party special needs trust to receive her proceeds so that she can continue to receive SSI. We've got a daughter without a disability, and the parents in this particular case just want that daughter to get her shares outright. You can see the different types of assets that the parents have in their estate. And, generally we think that the daughter with a disability any income that is received by that IRA will pass out directly to her because she's going to take some distributions. So let's imagine you have $100 worth of income that comes in from the IRA, and the beneficiary spends $100, or excuse me, the trustee for the beneficiary spends $100 on that beneficiary, or has $100 in trustee fees, et cetera, et cetera. Basically, that income gets passed out to the beneficiary or offset by those fees. And all of a sudden, we're not looking at any tax penalties, or excuse me, taxable tax liability for that particular event. So if we just look at the IRA and think about splitting it, look at the daughter without a disability. Look how much she's going to pay each year if she has to take it out as a DB, right? Over 10 years. She takes $50,000 out each year. She is taxed on her tax liability, excuse me, $16,000 on that income every year. Whereas for the third party special needs trust, the daughter without a disability, you can see the RMDs are less. Great. We are stretching that out over time. This doesn't assume any growth in the marketplace. That I've run those analyses before. It basically works out the same because you see how little in taxes she potentially owes just on that required minimum distribution. So while it's noble to try to treat both daughters the same, and you can in terms of dollars, it can make a lot of sense to dig a little bit deeper, analyze that particular, that the IRAs, treat them as a separate animal, have somebody that's very well versed in this. I always say, when I'm talking to neighbors or friends, oh, well, I'm going to have the guy that handled my divorce draft my estate plan. And I just kind of look at people and I go, if you drove a Ferrari, would you take it down to the local shop to get the oil changed, or would you take it to the dealership? Well, you take it to the dealership, right? And so why would we play fast and loose with something as important as our children's futures? So especially when we're dealing with people with disability, and that's why I can't recommend enough going out, spending potentially a little bit of extra money, actually probably not because it's what they do all day, and finding the most appropriate elder law attorney or special needs trust attorney that fits your clients or your particular situation. I don't want to deal with the proceedings today. This is really esoteric and contemplates sending a K1 to Medicaid. Um, so with that, I think there's only 4 minutes left anyway. I'm going to wrap it up, but let me just take a second to let me take a second here just to thank you all for the work that you do. We're in some pretty uncertain times here when it comes to public benefits and the impact that any potential reduction may have to people with disabilities may experience. And there's a lot of uncertainty with dealing with people with disabilities, who I think is one of the most underserved, but probably one of the most deserving populations in this country. And I want to thank you guys for all that you do and really helping your beneficiaries through some pretty uncertain times. Without you, I mean, you're a lifeline as a fiduciary to a lot of these folks, and I really appreciate the work you do and keep it up. Thank you so much.
Hey, thank you so much, Peter. Appreciate your time today. And after this session, if you wouldn't mind going over, this is to the attendees, wouldn't mind going over to the Secure Act 2.0 session information. There's an opportunity for you to give some feedback to Peter and let him know what you thought of the presentation and say thank you and all that. What we're going to do though is we're going to break. We're going to go into our final session of the day here. And that's going to be starting at 3 o'clock exactly. And so if you'll take a little break, and we'll see you at 3 o'clock back on the platform. Thanks again, Peter.
Thank you. Take care.